next case to come before the court is Lubanovich versus McGlocklin. Both sides, I should say, will have 15 minutes to present your arguments to the court, and the appellant may reserve up to 5 minutes. You may proceed.
Thank you, Your Honor. Good morning, Your Honor. My name is Christopher Jankowski. I represent the appellant, Stacy McGlocklin. The gist of this appeal is that the trial court erred in the amount of damages it awarded to the Lubanoviches, plus ordering the date that interest runs coming from the first judgment entry, not the second judgment entry. Pursuant to agroplastics, plaintiffs have the burden of proving the nature, extent of their damages. This must be shown to a reasonable certainty, can't be speculative. And when it comes to repairing damage to a building, the proper measure of damage is usually the reasonable costs necessary to restore the structure. The trial court, in issuing the second judgment entry, awarded the Lubanoviches $3,267.97. This came about from Stacy McGlocklin's testimony that he would have rebuilt the basement wall for $2,500, plus some exhibits that were in evidence of the Lubanoviches' costs for some construction materials, receipts for construction materials. That amount was $767.97. So essentially what the trial court did was take Stacy McGlocklin's statement of what it would cost in all to repair the wall and added that to what the Lubanoviches paid out of pocket for construction material.
And that seems reasonable.
Well, I think that would be in excess, considering Stacy McGlocklin indicated that he would redo the job for $2,500. There was no indication on record whether stating that that was just labor costs, whether that was just construction material profits. It was the flat $2,500 to completely repair it.
Had he observed the basement where the damage was?
I'm sorry?
Had he gone to the home and observed?
Yes, he had observed the damage.
So he was aware of the extent of the repair that was required to fix the wall?
He was.
Okay.
But as I did note, that $2,500 didn't really account for labor costs, construction material, other costs, profits. It's not quite clear how that would be broken down. It seems the only firm amount in the record appears to be the construction material that the Lubanoviches provided. Edward Lubanovich, he did say he calculated his own labor costs at $10 per hour, but there was nothing in the record as to how that was allocated, how much time he put in.
Well, back to the defendant's testimony, the trial court heard that testimony, and obviously it was maybe specific questions weren't asked as to whether that's just labor, whether that's for the full project or whatever. But contextually, and obviously we'll read the transcript again. But the trial court, I'm not sure I understand why the trial court would reasonably have interpreted that to mean that that's $2,500 for labor and that doesn't include the materials.
Well, I think,
because you said there's really nothing either way.
I think in my brief, the transcript is quoted with regard to
A few lines.
a few lines that Mr. McGlocklin indicated he would do the job for $2,500. That seems to indicate everything involved.
I'm not sure. I'm not sure, that's why I'm asking you to elaborate on it a little bit, because the trial court obviously didn't take that position.
And I guess it could just be a difference of how it's interpreted. In my mind, generally, when someone says, I could do the job for $2,500, that would include everything involved, labor, costs. I wouldn't expect anything in addition to that.
And obviously, you have to go just by what's in the record.
Exactly.
I'm thinking about people that have come out to my house and given me an estimate, and they're like, and now you need to get this, you need to get that, you need to get this, you know.
And I think that would be, I feel the interpretation, as I previously mentioned, 2,500 would encompass everything.
I understand. Thank you.
With regard to the interest, the trial court ran, on the second judgment entry, trial court ran interest from the date of the first judgment entry.
Before we get to that,
Okay.
I just thought of something I need to ask. So really, what you're arguing about is the $757.
Well,
Because if there's liability, which is not an issue.
it's not an issue. That's,
So if
we're not
your
disputing.
guy testifies, I can do the job for $2,500, and then the trial court tacks on $757, can you reasonably argue that $2,500 wasn't worth it?
Well, there's nothing in the record to suggest that is reasonable. It's just what
Well,
Mr.
here.
McGlocklin would have done for it.
But he's the one who did the construction in the first place.
Right.
I was just going to say, well, if he's not credible, and it would be, a good basis of damages, I don't know what more you can offer.
And
I'm not trying to put you on the spot.
right, and
That's my
clearly it's
job.
not in the record, and there's nothing suggesting anyone else provided
Right.
their other estimate. That's all we have to go off of. But unfortunately, the record is pretty limited. It doesn't suggest that's reasonable.
You wanted to get into the prejudgment.
Yeah, briefly. Thank you, Your Honors. There are a few cases I'd like to reference. One is Armstrong versus Modern Sales and Construction. It's cited in the brief, 1986, Ohio Ave, Lexus 6988. And the facts aren't similar, but the way the judgments ended up are pretty similar. And there was a judgment that was, liability, I believe, was upheld on appeal, but they vacated the damages award. And there was nothing, the Court of Appeals, when it remanded to the trial court, didn't state any specific amount that was affirmed. And the court noted that interest would go to the first judgment had a specific amount been affirmed on appeal. But since there wasn't a specific amount affirmed by the trial court when it was sent back on remand, that judgment would then start on the date of the second judgment. And there's a federal case, the Sixth Circuit, provided just for persuasive authority. That's Atkins versus Asbestos Corp, 18 F3rd 1349. That says when an entire damages award is vacated and remanded, the proper calculation of interest is from the date of the second judgment.
So what do we do with, in looking at that case, with the fact that the defendant has the opportunity during all of that time to invest his or her money and earn interest?
I'm sorry, I'm not clear
In the
about the
situation that we have here,
Yeah.
plaintiff has prevailed at trial, but defendant appeals.
Correct.
during that time, the defendant has the opportunity to invest his or her money vis-a-vis the judgment that would have been paid, that would have been due. And they get the benefit of the interest during that time. The plaintiff does not. What do we do with that if we accept your position?
Unfortunately, none of the cases, that's never come up in any case law I've read, and I feel.
Well, it's the basis upon which interest is granted.
I'm sorry, can you repeat that?
What I just articulated
Okay.
is the basis upon which post-judgment interest is granted by the courts.
Mhm.
Because the plaintiff is losing money that it would otherwise be entitled to the use of during that process. And the defendant has the opportunity to invest that money and gain interest.
Mhm.
Do you understand?
Yeah, I do. And it, as is the case in Armstrong, in the event of a certain amount that's actually affirmed, then it'll still run from the first day of that judgment. It's just the case where the entire award is vacated. And it appears in this case that nothing was affirmed, no amount was affirmed, it was just set back. I believe.
Counsel, I'm going to interrupt you for a second. Did you want to save some time?
No.
Are you sure? Because you have like 3.5 minutes if you want to.
Not on
Thank you.
Thank you.
Thank you, Counsel.
I believe.
So your position is, and I don't mean to put words in your mouth, but I'm trying to understand it, is since this court determined that the amount that was awarded to the plaintiff was incorrect, that your client is not receiving any benefit of that incorrect amount because he should never have to pay to begin with. The only thing that he is responsible for is the amount that was the correct amount, so the interest should run from that.
Right. And I think that pretty much sums up my argument.
All right.
Thank you.
You have 15 minutes.
Pardon?
You have 15 minutes. ma'am.
Thank you.
Thank you.
May it please the court, my name is Nancy Lubanovich, and I represent Edward and Nancy Lubanovich, pro se. I will be using the first pronoun when I'm describing myself, first person pronoun, and I will be using the collective pronouns for Edward and Nancy, just to make it a little bit easier to understand and for me to actually describe what's going on here.
And you know, I don't mean to pick on you, but I always say that's unfortunately my job sometimes. But technically speaking, he's being a gentleman, he's not saying anything, but technically speaking, you can only represent yourself because you're not a licensed attorney, right?
Right.
That doesn't mean that we won't, you both signed the appeals, that doesn't mean that we won't consider, you know, your husband as well, but technically you don't speak for him as an attorney, because you're not an attorney.
All right. Well,
Okay.
I will only be using him in reference as to the testimony then.
Okay, that's fine, that's fine.
We have a couple of alleged errors to argue, and one is the amount of compensation that was awarded to us and how it was determined by the trial judge. I should say the counsel for Mr. McGlocklin alleged that Mr. McGlocklin had provided a business estimate. And what I had asked during the testimony was, did he offer to rebuild the wall? And if so, was he going to charge us? And he said yes, for $2,500. This alleged business offer was offered on the day of the collapse. It's speculation to call this a business estimate. Nowhere in the record did Mr. McGlocklin ever talk about an estimate. Counsel for Mr. McGlocklin knows that it's not the duty of the trial judge to interpret or construe testimony or enhance what was said.
Well, let me stop you. The reason this court, as articulated in our opinion, sent the case back, we said that you were entitled to some damages, but the court had given you too much because you really didn't present evidence for that amount. So there has to be, you seem to be attacking the defendant's evidence that the trial court relied on and saying that that's not reliable. So if you do that, that's fine, that's your choice. But then then the trial court got it wrong, and by relying on that evidence.
I understand what you're saying. And really, I'm not attacking that it was not evidence, it's just how he was interpreting that evidence, that he was saying that it was a full business estimate. And that would include labor and cost of material and that sort of thing. There's nothing to justify that. There's no testimony on the part of Mr. McGlocklin that said that that was a business estimate. And you also have to consider, would we have asked for an estimate? We had just gone through a collapse, and we had many unpleasant experiences with Mr. McGlocklin. We had things like his not ever showing up for days at a time, even though the weather was perfectly good, that there was a dispute between Mr. McGlocklin and my husband about the perimeter drains and who should be responsible for them. Some of the drains were laid uphill. There was no protecting some of the structure that was used to lift the house against the weather, and that was causing erosion. There was not proper supervision of his workers. They constructed 2 windows on the north side where there were to be no windows. And the disrespect that Mr. McGlocklin gave to our neighbor, getting in his face and swearing at him. And also the fact that the basement floor was not 4 inches thick like the contract had allotted. And the north wall had collapsed within 1 month. So it seems unlikely that we would ever ask for an estimate. This was just something that he offered. He would build it.
So you won the case.
Right.
So what evidence then did you present to show? And keep in mind, I know you're appearing pro se, there's not an attorney here, and I just want to make sure you understand, you didn't file a cross notice of appeal.
No, we did not.
Okay, so you really can't get more than the judgment.
We understand that.
Okay, all right. So what did you offer? Because I don't quite understand. It seems like you're saying that this $2,500 wasn't reliable.
Well, it's the barest minimum. That's what it is. It's reliable, but it's the barest minimum. It can't be blown up into anything more than it really is. It's just for the rebuilding of the wall. And that's what the trial judge used, and we understand that, although we believe it is incorrect. And we understand we can't get more money. We understand that.
All right. I just want to make sure we were all on the same page. I apologize.
Yes. There was also no evidence that any paper documentation was given for the estimate, or that he inspected the damage. Yes, he was there, but he never went down and really inspected the damage to see how much there was. And he never measured the length of the wall or made any attempt to determine what the cost of the building material would be. He might have had some ideas since he does that for a living, but he didn't really lay that down on a piece of paper or anything like that. When he offered that he would rebuild the wall, we inferred that the $2,500 was for our half to rebuild the wall. We have no idea what he was implying. We just have to take him at his word that he would rebuild the wall for $2,500. And we have to question, does that include materials? There's no evidence that it does. Does it include the bracing of the south wall that was in failure? Does it include the cleanup of the basement that was littered with pieces of block and cement? Does it include erecting a structure to protect the work site? Does it include building a temporary support along the north wall Does it include waterproofing? Does it include gravel and backfill? Does it include cleaning up the north wall, which was littered with the fill, the backfill, the cement blocks, rebar, and additional cement? And does it include the cost of the gravel, clean gravel, and clean fill? I could go on, but probably I don't need to at this point, since we can really not get any more than what the judge settled on, or came up as a reward or an award. But one thing that I can say is that we were very honest about our labor and materials. Our goal was to do the work as economically as possible, which meant doing much of the work ourselves. That was out of pocket for us. We didn't include all of our labor and expenses, so we were being modest, we were being conservative. In other words, during the brief, we were questioned. We felt it was a little bit insulting about our hourly rate that we used, and also the time that was reported. We did have a spreadsheet, although it was argued many times that it wasn't a spreadsheet. A spreadsheet is simply columns and rows, and that's exactly what we presented.
I think not so much it wasn't a spreadsheet, but it wasn't in the record.
Well, it was presented as evidence, and it was included. The only thing that wasn't included were three things. One was a picture that I had drawn of the wall and how it was constructed and the cause of the cracking, the horizontal cracking. That wasn't accepted. The other thing that wasn't accepted was an ODNR letter that indicated what kind of soil type we had on our property. And the last thing that was not included was an excerpt from the Medina building codes.
You said in your brief that that document was sent to opposing counsel.
Yes.
But it was not admitted into
It was
evidence.
also admitted into evidence. And they actually presented the evidence. I
Well,
forget
when you
what
say it was admitted, was it the one that included the picture and the things that you just spoke of, or the one that was without those changes?
It was separate. It was in a letter that we had sent to Mr. McGlocklin. It was the second letter that we had sent, which outlined all of our tasks and how much we felt that they were worth based on how much time we had spent and a $10 hourly rate. So that was evidence that they submitted. It was our evidence, but they submitted it. It was either A, B, C, or D. I forget offhand what it was right now. As far as the other area is concerned, the interest that was charged, since the only thing that was partially reversed was the monetary amount, the clock shouldn't be stopped and restarted when the final amount is determined. The damage occurred in 2009, and that was out-of-pocket expenses for us. It didn't happen in 2013, 14, or 15. We did not request interest from the day of the collapse, but were awarded by the trial judge interest from the date of the original settlement, and that should not be changed. It was not considered. It was not actually pre-trial interest. And there is no evidence that Mr. McGlocklin or his counsel ever made an attempt to settle, whereas we did. Thank you.
You do have a little over 2 minutes if you want to reconsider. The court will take the matter under advisement, and I appreciate both of you coming and arguing today. And a written opinion will be sent to you just like last time, as well as you can look on the Supreme Court and the 9th District Court of Appeal websites for its release. Thank you.